everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Mr. Navneet Singal with us. Navneet is currently working as the head of tax and digital transformation in Syngene International Limited of Biocon Group. And he carries over 20 years of experience in the field of taxation, BEPS strategy, litigation management, industry, and regulatory policies. During his stint in different MNCs, he has worked in different verticals of industries, which includes IT, ITES, infrastructure and power, oil and gas, and currently he is in the pharma industry. So now, without further ado, let's dive into more about him. So, hi, Mr. Navneet. Thank you so much for joining us.
Yeah, hi Nikhil, how are you?
I'm doing great, sir. It's really a pleasure to have you here.
Yeah, thank you. Thanks a lot for giving me this opportunity to be here with you and to just share my view.
Right. Mr. Singhal, please tell us about a complex legal issue that you worked on and also describe the complexity and tell us how you approached it.
Nikhil, I am working from the last 20 years, you can say, in this legal industry and tax aspects. So there are a number of issues which has happened during this period. But first, I would like to say that interpretation, which I generally say that each and every issue, there are thousands of interpretation, and that is our legal challenges that there we have to define that how we have to tackle it. If you talk about one of the most beautiful, I should say, issue, which has recently happened during the last 2 years back when we get a investigation from the GST department. The issue was like the services which we are providing as a pharma industry and which we are doing R&D, whether those services we are providing in India or outside India, whether those are export services or not. Because there are some clauses in the earlier design of service tax which says that if you are getting a material and that material is essential part of the service, then the place of the service from where you are providing the services should be treated as a place of service. So in that circumstances, like all of our laboratories are in India and we are providing services through, you can say, India, and we need some material, very small minuscule material for the purpose of taking forward that R&D. So all of our services, which are like 2,000, 3,000 crore, were considered as a local services, domestic services. While this is a big gamut where all of our clients are outside India, and it is a R&D services typically, and that material which we are getting is a very minuscule part. So then you can say we have to define that, no, boss, this is not something laboratory services like Dr. Lal Path Lab or like SRL laboratories, which are just taking blood and doing the test. It is R&D. And we are providing export services, not domestic services. So these kind of legal interpretations comes a number of times in our way. Sometimes like whether you are doing manufacturing or services, or sometimes it is a production. So it's really enjoying to define all these typical issues. I should say like that.
All right. And how do you see the existing framework of international tax on which OECD is working for the applicability of minimum tax rate and providing relief in terms of double taxation?
Yeah, international tax, like with global, you can say everything we see that business is increasing like globally from one country to another country, then there are no limits, no boundaries. So in such a case, tax regime has become a big issue that whether we should incorporate our country, whether we should manufacture, whether, because each and every country has different type of tax regime. So in such a case, number of companies are just establishing their units or their companies in such a country where there are minimum tax rate or nil tax rate. They are known as tax havens. So to come out from that thing, a lot of, you can say, work is going on from the last 10, 15, or I should say 20 years. But recently OECD has come with a pillar 1, pillar 2 aspects. Where pillar 1, they are trying that the overall profitability of the company should not reside in one country where the minimum tax is there, and that can be distributed among other countries also where actually consumption is happening. In the same way, in pillar 2, they are trying that some minimum tax rate should be there on a company. Like if a company is earning worldwide profit of 1,000 crore rupees, then they should be minimum 150 crore rupees worldwide tax. And if that will happen, like a lot of work is going on that pillar 1, pillar 2 aspect, and within maybe 1 or 2 years, some framework will be implemented. Like a lot of work is going on that framework. So once it will be implemented, all the double taxation related issues, like in one company, in one country you are paying tax, in another country you are also paying tax, then you have to take the refund from one country to another country. So all these typical tax related issues, which all the, you can say, companies are facing, all the incorporate entities from in different countries are trying to fight with the tax authorities, will get resolved.
Yeah. On tax and legal technology, as well as digital transformation in general.
Tax technology, if I say that tax technology is the future of the next decade, or I should say next 5 years, where you will see that within 5 years, the total overall tax compliance and regulatory regime has got totally changed, because now we are talking about digital transformation. What is transformation? Like we are moving from, you can say, one angle of where a lot of work is going on through manual processes will totally automate. Like you have to just finalize your financials and all the tax returns will get automatically prepared. So you will not be required to even file the tax returns. The government will automatically send you directly the order or processed returns. That time is not far. Like there are a number of technologies. Like if I see in India specifically, we have total e-invoicing system. And in e-invoicing, as soon as you procure the goods will come into the government portal through e-web system. Then they track it through e-invoicing. Then there is input ITC, output ITC. In the same manner, when all these entries get happen, nowadays you can see that your income tax returns are half cooked already by the department. As soon as you open the portal, you can see that there are a number of entries related to your interest income, related to your salary income are already there. So everything is going to be digitalized very soon, and we have to see that how can we make our company pace with that, and all the interpretation related matters which will you can say discretionary thing for all of them. So that will be there always, but you have to understand the technology and see that how much can you do utilize that in your system.
Okay. And the pandemic saw some courts begin toward moving towards more remote proceedings and availability. Is this sustainable and a possible way to increase access to justice, in your opinion?
It is a great challenge, no doubt, when courts are talking about a lot of technology and see that person should not be, you can say, present in person itself, or there are virtual hearing, because it is a some kind, I should say, is a psychology, human psychology. India is in one of the first country, I should say, worldwide, where they have tried to implement virtual hearing at the appeal level, commissioner level, and after that tribunal level, and now slowly they are also trying it at High Court and Supreme Court level. Even due to this COVID situation, at number of places it has already started also. But whether when you present yourself in person, are you able to show your complete, well, express yourself completely? And once the order is passed by the court, whether you will be able to justify completely, because number of times person want that he should be heard personally up to, you can say, tribunal level. I can say that okay, because there is a fact finding process, and you can say that the facts are more presented through data documentation. But once you prove that, when you appear in the court, a lot of things depend upon your spirit also, but whether that can be justified. So it is going to be a big question mark in future, that how this virtual hearing will substantiate its presence or its, you can say, justification.
And now that you have worked in IT, pharma, infrastructure, oil and gas, and other industries, what are your thoughts on working in different spheres of the industry, effect one tax and legal situation? And how much one has to associate himself with the integrity of business while working on it from a tax and legal standpoint?
It It's really very important whenever you provide any consultancy to any company, then you need to understand the business. Whether it's in my 20 years of career, I have worked in different fields like information technology, where I have worked with HCL technology. I have worked in pharma with Biocon Group, where I am currently working. I have worked with the overall infrastructure with GMR Group, and also if you ask, I have worked with Shell. So it's a like different industry, and each business has their own integrities. They have totally different revenue models. They have totally way of different workings, their clients, the way work get done in these industries, like when it typically R&D industry. In pharma, it takes a minimum 10 to 15 years, such a long gestation period. IT is like today you think and tomorrow you can set up the business. Only with a, you can say, very small laptop, you can start provide services. So it matters a lot when you understand the business, that how you have to work along with the business, because it is very important for a legal person to understand that how business is going on and how to provide their services, being a part of the business, operating units, heads. Business want to understand that how they should enter into an agreement which can give them the maximum profits and the minimum litigation, and they can get the maximum benefit out of it. But if you don't understand the business, you can't do it. Because when you go in detail and each and every activity, only then you will be able to understand that, like just I told you, that whether it's a manufacturing or whether it's a service, and how the tax will be applicable on that. If you don't understand exactly that how the work is going on the ground, you will not be able to provide your consultancy services properly, accurately. So it is really very important to understand the business.
Thank you so much for sharing such great insights with us. And we look forward to having a chat with you again in the future on some other trending topics in the international legal world. So for our viewers, if you like this chat with Mr. Navneet Singal, please like and share this video, and also subscribe to Clickaway Creators YouTube channel to appreciate what we do. And you have more coming from the international legal space. And this is Nikhil for Let's Talk World signing off.